Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I just got back from the National Immigration Lawyers Conference and was pleased to meet several people, several other attorneys across the U.S. who regularly watch my videos. I appreciate it. Glad that you all enjoy. If any of you have any comments, good or bad, just go ahead and send them to me. I know that the decision in U.S. v. Texas is disappointing, but if any of you have had an opportunity to read the decision, there is no analysis, there is no affirmation of any kind other than a one-sentence ruling that essentially the court is split 4-4, therefore the Fifth Circuit ruling stands. So first, you can see what happens when there's not an odd number of people on the U.S. Supreme Court. You understand that the current nominee to be on the U.S. Supreme Court is being blocked, that nothing's going to happen for some time, and that the business still goes forward. So if it's a 4-4 split, that's what it is. So, obviously if there was another person on the court, it may have gone the other way, one way or another, but what I'm feeling from a lot of my clients that call and a lot of potential clients that call is they think the world is over, okay, that there's no hope and that there's nothing that can be done. That's not exactly true, okay. This particular decision, while it would have been very nice to have the Fifth Circuit decision overturned, the reality is it dealt with a new form of DAPA, which is basically just a temporary work permit for parents. It expanded DACA and did some other stuff, but it did not give lawful permanent residency. It did not give citizenship. It didn't give a path to residency or citizenship. All in all, again, while it would have been nice, the bottom line is for various people it gave work permits, temporary work permits. It didn't change all of the other areas of immigration law and all of the other ways upon which can help those people who are here illegally. There's a plethora of different visas and of paths that one might be able to go on in order to obtain status. For example, there's the U visa, victims of crime, the T visa, victims of trafficking, and that can also be people who have worked without pay, who are basically extorted to do what they do in order to basically not get deported, or the threat of not getting deported. There's adjustment of status depending on, if you qualify and what your family relationships are. There's all kinds of waivers in immigration law that essentially deals with when you are inadmissible for one reason or another. And basically it's a preparation of attorney cover letter, declarations, affidavits, evidence to essentially make that ground of inadmissibility disappear and have immigration say it's okay, you can come in. There's ways of fighting case in immigration court, cancellation of removal, there's asylum relief, convention against torture, withholding of removal, there's registry relief, there's humanitarian paroles, humanitarian reinstatements, consulate processing. There's ways of appealing, doing motions to reopen, doing writs of certiorari, petitions for review. I could go on and on. So the whole area of immigration law and what is available to the people who need help is still there. I'm not saying it is a wonderful system and doesn't need, comprehensive immigration reform, but who knows? Maybe because of this decision, maybe the next session Congress will actually move forward and do some kind of relief some kinds of immigration reform. But in the interim, we have what we have. But the message here is don't despair, because the Supreme Court deadlocked on this particular issue. It doesn't make everything else disappear. It doesn't make all the different ways that you might be able to obtain legal status or protection from deportation disappear. So if you like the video, click likes, subscribe, and you can certainly give my office a call. Be happy to give you a free consultation. Okay, more on the coming videos.